We had no trouble getting top-ups 10 years ago. It's changed for a whole lot of reasons. But it is absolutely critical, as Will said, that you watch those dates, because in 1 week, a little while ago, we had 3 people come to us and say, we forgot to exercise the option. It's critical that you know those dates and do that. I'm going to talk about avoiding a RAN and then what to do when you get a RAN. A lot of what I'm going to say tonight has been said by people before me, so I'll try and make that part of the presentation as short as I can. A RAN will damage your business. It will be there on the records for a future buyer to see. You need to avoid it at all costs. Apart from damaging your business, as anybody here who has been through the RAN process will know, dealing with the RAN is very expensive. You will normally have to engage an expert to verify that you've done all the things you're supposed to do. You'll invariably have to engage a lawyer as well. And engaging lawyers who do litigation work like RAN is very expensive. I have, from memory, only seen one RAN that relates to letting. Every other RAN relates to caretaking. So letting seems to take care of itself pretty well. It's the caretaking where we have the problems. Mike said this before, service. Recognise your role. You are, under the Act, a service contractor. You're contracted to provide services to the body corporate. Please don't approach your business on the basis of how can I do less and get paid more. It doesn't work. There might be the odd time it does when you have owners who don't seem to care about their building, but 99% of the time that doesn't work. As Mike said, understand your duties. Carry them out and tell the owners what you're doing. Mike talked about sending out photographs, etc. Kelly talks about a newsletter, exactly that. As I've said at these presentations before, for whatever reason, we people in Australia tend to take great interest in our lawns and gardens. We love them. I love them. And most people do. And if you can get that right and the cleaning right, that tends to satisfy most people. Mike talked about over-servicing. I'm saying here reasonable might not be enough. Doing a reasonable job might not be enough, particularly if you're working in a very upmarket complex somewhere where you're being paid a lot of money to look after it. I had some clients once whose daughter did some work for me, and she said, Mum and Dad were shown this complex by the agent. It was like a resort. It was permanent complex. It was like a resort, she said. And they fell in love with it, and they bought the management rights. It wasn't until after they'd started that they realised it was their job to keep the place looking like a resort. Doing a reasonable job in that place may not have been enough. I encourage my clients to try and arrange to walk around the complex regularly with their liaison person, whether that be the caretaker, whether that be the chairman or the secretary or somebody else. If you do those walk-arounds and that person is pointing out to you what you do or don't need to do, then they can hardly go to a committee meeting in a week's time and complain about what you haven't done. If you've had your walk around, you've made a note, you've done it, they can't complain about it. Relationships, I don't need to go through that again. Mike and Kelly talked about that. Likewise with that, you need to be seen as the one who drives everything. And if you can, avoid disputes. I learned from someone in a mediation a long time ago that one way to de-escalate or to minimise a dispute is to try and find some common ground. And if, for example, the chairman's complaining to you about the state of the tiles around the swimming pool, you can agree with him. Say, I agree. They're terrible. They need to be cleaned professionally. So it takes that heat out of the argument. So whenever you can find an opportunity to agree with someone who's having a go at you, do so. You disarm them. You take away their anger. Not always easy, but you've got to do everything you can to avoid disputes. So what is a RAM? It's a Remedial Action Notice. That's what it's an acronym for, Remedial Action Notice. It must specify the breach. So, for example, it may be that they allege that the gardens on the eastern fence line are full of weeds. That might be a breach. The breach might be that you aren't providing the reports to the body corporate that you're supposed to provide. So it needs to specify what that breach is. It must also specify how you are to remedy that breach. For example, it might say, to remedy that first breach, you need to remove all the weeds from the garden and keep it without weeds at the end of the period of the notice. It must give you a reasonable period within which to remedy the breach. It has to be at least 14 days under the Act. If you fail to remedy the breach, that gives the body corporate the opportunity to terminate the agreement. The body corporate can only terminate the agreement at a general meeting where a majority of those who vote to terminate the agreement. There's lots of reasons why body corporate shouldn't terminate an agreement, because if they try and do it, the first thing that happens is that they have to notify your financier. So they can't terminate the agreement without notifying your bank and giving your bank the opportunity to step in and remedy the breach. So, in all the ones that we've done, I can think of maybe one where the body corporate actually got somewhere through going through a termination process. So, if you get around, what do? Don't ignore it. We've had people come to us, they've got a RAN, they've been given 21 days to remedy it. They come to us on day 30 and say, I've got this RAN. Not a lot we can do if they haven't remedied that RAN. So don't ignore it, but by the same token, don't panic. Very, very few. As I said, I can think of only one RAN that I'm aware of that has led to a termination that we've been involved in. Contact a lawyer experienced in management rights and particularly litigation. If there's a number of minor issues, like weeding the gardens, that kind of thing, deal with that, take photographs of that. And it's important that if you've been given, say, 21 days to do something, don't do it on day 7 and then wait for the weeds to grow again after that, because the weeds have to be out of there on day 21. That's the critical day, whatever they've given you in terms of that number of days. If it's a really, really serious RAN, discuss with your lawyer whether you ought to talk to your bank and let them know what's going on. We generally don't. It doesn't assist us. Very rare that it does, but at least discuss that with your lawyer. We typically suggest that you get an expert to assist you to deal with the RAN, to sit down with you in conjunction with your lawyer, go through it, work out which things are your responsibility, which things are the job of a specialist contractor, how do we respond to this RAN. that expert will work with you, and on that 21st day, they'll be taking photographs, preparing a report to show that you've complied with the RAN. If there are things in there which are properly the job of an external contractor, then you ought to get quotes to get that done and provide those quotes as part of your response to the RAN. We suggest a formal response to the RAN, to go through it item by item, using the expert's report, and put back something to the body corporate so that they take serious notice of it, and they're less likely to go ahead with anything after that. If it's something which is not a genuine attempt by the committee to terminate your agreements, but it's more designed to overcome what they see as being failures, then try and work with the committee. If the RAN has some basis to it, and it is the case that there's been areas that have been neglected, try and work with the committee to work out how you can deal with those things and resolve their concerns. I'm not suggesting that every committee is able to be worked with. There are some that just won't. I accept that. But most of the time, the RANs are issued because there is a problem that needs to be addressed. Do whatever you can to stop the committee from going that next step of calling a general meeting. You just don't want that. It often works for us that when the committee understands what's involved, they'll back off. You remember, or you'll appreciate that if the committee's getting legal advice from a law firm, the law firm is probably going to encourage them to take it as far as they can, because the law firm makes money out of that. I don't like saying that, but it's true. Yeah, go for it. We'll get these people. I mean, you can be like the Grange, and you can spend, I think by the time they paid the manager's costs and their own costs, they spent well over $1 million in legal fees. As I said, we've only seen one of these things ever get anywhere, but 99 times out of 100, the body corporate spend an awful lot of money and they get nowhere. The best they can hope for is that they get to the point where your bank steps in and sells the management rights. So they're never going to terminate the agreements. And if the committee members and the owners understand that, then you can generally get them to vote against the termination. This is an example of one where we didn't act, by the way, but a termination on the Gold Coast. So the RAN specified 41 breaches. QCAT decided that 20 of those were valid and were not remedied. Some of the examples where they hadn't remedied were weeds in lawns and gardens. Now, I don't know how hard it is to get weeds out of lawns and gardens, but it's not that difficult. Dirty stairwells in common areas, dirty light fittings and dirty windows. They're examples of things that were actually done. There were 5 breaches that were valid but not complied with, so that the 20 were ones that were genuine breaches. Of those 20, there were 5 that were valid but not complied with. 16 breaches were invalid. QCAT expressed the opinion that the manager clearly lacked an understanding of what his duties were. And there was a failure to comply with valid breach notices, and the agreement was terminated. The manager there represented himself in QCAT, which is not advisable. So avoid RANs. If you get one, don't panic. You'll be able to deal with it. We'll get you through it. but do your best to avoid it. That's all I have, but for those who have spoken, we might take a seat up here and let you people ask us whatever you wanted to, and even after question time.